At the U.S. Department of Agriculture's National Appeals Division, we believe in face-to-face fairness. We are a nationwide staff of experts who help resolve errors and disputes over certain USDA program benefits by giving participants a fair and timely hearing. The appeals process applies to programs from USDA's Farm Production and Conservation, or FPAC, mission area, Farm Service Agency, or FSA, Natural Resources Conservation Service, or NRCS, and Risk Management Agency, or RMA. The process also applies to programs from 3 agencies with the USDA Rural Development Mission Area: Rural Housing Service, or RHS, Rural Business Cooperative Service, or RBCS, and Rural Utilities Service, or RUS. Participants in programs from these 6 USDA agencies who receive an adverse decision impacting their participation in a program or receipt of benefits can file an appeal with NAD within 30 days. The appeal must be 1. in writing, 2. signed by the qualified person who wants to appeal the decision, and 3. filed with the appropriate NAD regional office. Filing can be done by mail, fax, or e-file. To e-file or find the office nearest you, check out the NAD webpage, nad.usda.gov.
We've got your application here.
Agencies may determine that some decisions are not appealable. However, where a regulation or rule is applied to an individual situation, the dispute is appealable to NAD. If in doubt, contact NAD at the address on our website. So what are some of the common issues and types of cases that NAD sees? They include questions of program eligibility, compliance, amount of benefits, and repayment demands. More specifically, for FSA and NRCS, we see cases involving a wide range of programs, such as the Conservation Reserve Program, CRP, the Agriculture Risk Coverage, ARC, and Price Loss Coverage, PLC programs, the Conservation Stewardship Program, CSP, the Livestock Indemnity Program, LIP, Non-Insured Crop Disaster Assistance Program, NAP, Wetlands Concerns, and various other programs. For FSA, we also hear cases involving loan issues, ranging from loan denials to servicing and foreclosures. For FSA and NRCS programs, equitable relief is a common issue. The concept of equitable relief deals with the opportunity to receive benefits or other relief, even where you do not meet all the program requirements. Equitable relief may be available where you 1. relied on FSA or NRCS action or advice to your detriment, or 2. used good faith efforts to meet the program requirements. For RMA, common examples of cases we see involve ineligibility, that is, failure to make timely payments on crop insurance premiums or written agreement denials, and adjustments of large loss claims or yield disputes. For RD, typical cases involve loan or grant denials and accelerations and servicing issues, such as denials of payment assistance and moratorium requests or unauthorized assistance demands. For more information about the types of cases we hear or to research prior decisions, please go to our NAD webpage, nad.usda.gov, and there you can select Search NAD Determinations and enter in keywords and other information to find past decisions. So, what can you expect once you file an appeal with NAD? First, the NAD Regional Office will assign your case to an administrative judge by sending all parties a notice of appeal and request for agency record. Next, the administrative judge will schedule a pre-hearing teleconference with you, the agency representative, and any other parties to the appeal. During the pre-hearing, the administrative judge will work with the parties to identify and develop the potential issues, prepare the parties for the upcoming hearing, and ensure that they are comfortable with the process. At the pre-hearing, you will elect an in-person hearing, telephone hearing, or a decision on the written record. In-person hearings are conducted in the appellant's state of residence to accommodate face-to-face fairness. During the hearing, both you and the agency will have an opportunity to present your position and evidence. Let's briefly listen in on a hearing.
I've turned on the recorder at 8 a.m. This is a National Appeals Division hearing concerning Mr. Farmer and the ABC agency. NAD case number 123456789. My name is John Public, Administrative Judge. And by
A hearing consists of 4 parts. In the first part, the administrative judge covers procedural matters, including confirmation of the adverse decision and the issues under review.
Mr. Farmer, do you affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
I do.
And Mr. Agency Representative, do you certify that the evidence that you have submitted or will submit is true, correct, and complete to the best of your knowledge and belief?
I do.
In the second part, each party has the opportunity to make a brief opening statement. Next, each party will explain their position in detail by presenting arguments and evidence. This is the main part of the hearing, during which each side explains their documents and questions witnesses. Finally, in the fourth part of the hearing, each party has the opportunity to make closing statements to summarize their position.
Since the appellant bears the burden of proof, I'll give him the last word in this matter. Mr. Agency Representative, would you like to make a closing statement at this time?
Yes, I would. Thank you, Your Honor. The evidence presented today clearly shows the documentation has everything that the agency requested.
Along the way, the administrative judge may ask questions to clarify the parties' positions and evidence. The administrative judge will make closing remarks before concluding the hearing. After the hearing, the administrative judge will review all information presented and made a part of the case record. The judge will consider such information in connection with the applicable laws and regulations to determine whether or not the agency decision was erroneous. Within 30 days from the date the record closes, the administrative judge will issue a determination. Finally, if either party disagrees with the administrative judge's decision, such party may request a review by the NAD director. The administrative judge's determination will explain how to request a review, or you can visit our website for information about how to request a director review. We hope this information has provided a helpful overview. Before we close, let me give you a few pointers when dealing with the NAD appeals process. First, ask questions, avoid missed opportunities, and don't wait. Find out what you need to know to move forward in a timely fashion. Second, seek guidance and representation if you feel you need it. If you appoint someone to represent you, the person does not have to be an attorney. Third, focus on any misapplication of regulations or rules to your individual situation. And fourth, consider whether equitable relief is available. The U.S. Department of Agriculture's National Appeals Division is here to serve you, and that begins with the many resources available on our website, nad.usda.gov. You'll find regional phone numbers, contact information, and summaries of all the processes that are part of the appeals process. And through your appeal, you'll be able to have a full opportunity to present your case before an experienced administrative judge, whose goal is fairness to you. At USDA, we're committed to you and ensuring USDA is making correct decisions for the right reasons. We call it face-to-face fairness.